So let's talk about some contract doctrines. This is a really fun part of contracts class when you're a first-year law student. Uh, in a law and economics undergrad class, we won't get into some of the fun details on these things. But contract doctrines are important. They are ways to think about how contracts are entered into and how courts are going to enforce them after the fact. And an important way to think about these is there's no such thing as a complete contract. There are no contracts that were drafted a year ago that have exact terms for what should happen if there is a global pandemic that is viral in nature, that spreads through means like the novel coronavirus, and it leads to social distancing measures and all sorts of stay-at-home orders and restrictions on business. There are contracts that have lots of clauses that may cover some aspects of that, right? There are things called force majeure or acts of God that a lot of contracts may have some clauses that cover that situation to some extent, but I guarantee there are no contracts that perfectly cover this situation we find ourselves in. And that is a good example of there's no such thing as a complete contract. You can't write a contract that spells out contingencies for what to do for all the different possible things that can happen that can affect fulfilling a contract, even if it's a relatively simple one. The world is a complicated place. We live in a world of incomplete contracts. Now, that's okay. Contracts are still really useful. In fact, when we think about how much detail a contract should have, we can think about marginal benefit and marginal cost of adding additional complexity to a contract. And the efficient level of completeness is you draft until the marginal cost is equal to the marginal benefit of adding that additional complexity. And you don't draft past that, because at that point, your marginal cost is going to be higher than the marginal benefit you get from it, and it's not worth it. You're paying lawyers to write a really fancy contract for what may be a relatively simple transaction, or you're paying lawyers to draft for terms that are very unlikely to happen. And that's why we don't have a lot of business contracts that talk about global pandemics, novel viruses, social distancing measures, things like that going forward, or contracts being written right now to deal with current situation. Absolutely, they should be writing terms like that, right? The marginal benefit of having that spelled out is probably much higher than the marginal cost of adding a term like that, depending on what you're contracting for. But so we live in this world of incomplete contracts, and that matters because that means courts have to fill things in. After the fact, courts have to decide what under this contract should we do to govern this situation that is not spelled out directly in the contract. So how should we treat this fulfillment contract for products when there's social distancing measures and all non-life sustaining businesses are closed? Should we excuse the company for not being able to hold up its end of the bargain? In a lot of cases, probably yeah. They were doing what they had been told they had to do, right? So we don't want to blame them for that. But it depends. It depends on the circumstances of the case, what the contract is for, what sort of terms it does have in it. So there are some default rules for contracts, and these vary by state. It's governed by state laws. But default rules are basically, if nothing is spelled out, this is how we're generally going to interpret things and treat things. So one default rule that is common is we're going to interpret terms of the contract against the drafter. we're going to interpret them in favor of the non-drafting party. So if one party drafts an agreement, and we see that with adhesion contracts, take it or leave it sort of contracts. So end user license agreements are a great example of that. You try to use some new app, it lists up these legal terms, and you have to click I agree. You don't have any choice, right? The contract terms are what they are. The party making the product drafted that contract. You can take it or leave it. Either you agree to those terms to use that product, or you don't, in which case you can't actually access that product, right? That's an adhesion contract. And so courts will tend to interpret a contract against the party that drafted it in a situation like that. Now, the thing about default rules, it's a default, but if you actually have a term in the contract, that is what governs. So if the contract says this contract was drafted in the interest of both parties and it shall not be deemed as being drafted by one party or the other, and the default rule of drafting against the interpreting against the drafting party should not be used, well, there we go. We have a term in the contract that tells us what to do. That overrides any default rules that may be in the background in state law. There are another class of contract doctrines, though, that govern interpreting contracts, enforcing contracts, and they are mandatory rules. So they're not just a default that's going on in the background, there's something you can't draft around. They are the law. So there are contract doctrines for things like minors. If a minor enters into a contract, then that contract cannot be enforced against the minor unless it's a contract for certain necessities, food, shelter. So if you have an employment contract with a child star, what do? Well, they have contracts with the child star, but they also try to have contracts with the parents, and they try to have the relationship one that there are connections in various ways such that they hopefully have some sort of enforceable contract to try to keep the relationship going. So there are rules about incapacitation. There are rules about if someone is involuntarily intoxicated. Courts are generally going to say any contract they sign while they're in that state is going to be void. But so you can't drug someone, give them a bunch of roofies, for example. They don't want to take them, they don't know they're taking them, but you give them these drugs and then have them sign a contract. Courts aren't going to enforce that contract against that person. They are going to say that's void because they were involuntarily intoxicated. It's much more murky when someone is voluntarily intoxicated, which is a much more common scenario, right? So if someone drinks alcohol and they get drunk, they sign a contract, maybe they go buy a new car, right? Is that a legally binding contract that they can be held to? In most situations, yeah. Unless the other party knew that the person was drunk and they kind of took advantage of that. So not just that they knew they were drunk, but that they capitalized on it. That's when courts will start to say, this doesn't feel right. There are doctrines about duress and undue influence, coercion. If someone is holding a gun to your head telling you to sign a paper, courts aren't going to take that signature very seriously, understandably so, right? That would be coercion, someone threatening you with physical harm if you don't do what they want you to do with respect to a contract. But a much more common scenario is something like undue influence, where there's some sort of relationship, some power differential that, again, someone is capitalizing on, using to their advantage, we see this really often in elder care, that sometimes caregivers will, they provide essential care to an elder person. They may take advantage of the power they have to get nice terms in a contract with that elder. So that's where we see a lot of disputes over estates when someone has passed away and they have a will. Often there's, say, some members of the family who say, well, here's the will, and then someone else, maybe a family member, maybe not, who has a caregiver, says, but here is actually the real last will and testament that has some very generous things toward that caregiver. Understandably, that leads to some messy legal fights, right? And that's when you will often see questions about whether the caregiver had some undue influence over the person who was writing that will. So there's a bunch of these legal doctrines, contract doctrines, that govern how courts are going to interpret and enforce different contracts. There's too much nuance for us to get into all of them here. I mentioned some of the highlights. The slides do a nice job going through the basics of what a lot of these things are. They get really interesting when you start reading the cases for them. But unfortunately, we have to save that for those of you who are thinking about going on to law school. You can look forward to your 1L year and taking a contracts class.